All right, State of Arizona versus Lori Vallow, CR 2021-001704, as well as CR 2022-001242.
Attorney K, on behalf of the state, I think some of the next of kin we're going to be calling in virtually.
Okay.
Gerald Bradley, Danae Suki for the defendant. She has waived her presence.
All right, this is the time set for complex case management conference. Let me ask the state the status of discovery.
Your Honor, at this point, the state has disclosed almost 100,000 bait stamped pages, close to 15 terabytes of discovery material. We have just a very small amount left, some testimonial or immunity agreements that were given by the Idaho prosecutors in the Daybell trial that may relate to some of the witnesses that could potentially be called. So we're working on obtaining those. I think after that, all discovery will finally be complete.
All right. Mr. Bradley, last time we were in court, you indicated that your client did not want to waive time, that she wanted to assert her speedy trial rights. However, where are you in the going through the discovery and being ready?
Judge, you are correct. She continues to want to assert her speedy trial rights. I've made what I believe incredible progress going through the discovery, but even that said, I'm nowhere near where I need to be as far as completing review of everything that's been disclosed. I believe the state's accurate in summarizing what I need to do. So that's sort of my update on that. I can give you more details if you like, but I'm trying my best, but it's quite a task.
Well, how many pages of physical discovery do you have to go through?
Total, I think it's probably over 100,000, and I'm fine putting on the record my progress so far. I've gotten through about 8,000, which I think is pretty good, but it's, as you can tell, I still got a long way to go.
So I know you were reassigned this case. You've been on it since April.
That's right.
So in the month and a half since you've been here, you've gone through about 10% of the discovery, it sounds like. Is that fair?
If we're just talking about bait stamp discovery, I think that's fair. But then we also have, of course, all the reference recordings, surveillance footage, Cellbrite extractions, etc. that I really haven't made a big dent on those yet.
All right. I understand your client's asserting her speedy trial right time. It sounds unlikely you'd be ready for trial on August 1st. I think what I'm going to do is I'm going to set a status conference about 30 days before our current trial date to discuss realistically whether you can be ready for the first. I'd like to bring your client for that just in case we have to move that trial date. How about we set a status conference July 1st at 8:30 a.m.?
That works.
That's fine, Your Honor.
All right, we're going to set another status conference July 1st at 8:30 a.m. We'll order that Ms. Vallow be transported for that hearing. We'll discuss the viability of that August 1st trial date at that time. In advance of that, can you again file another complex case status conference report saying, you know, with some specificity how much discovery you've gone through, how much more, and a time frame of how long you think it would be for you to be adequately prepared for trial?
Yes.
All right. Anything else from the state?
No, Your Honor, thank you.
From the defense?
Judge, a few things. It wasn't in the report, and I did give the state a heads up, but as far as anticipated motions, I am planning to file a motion pertaining to media coverage. I anticipate maybe in 2 weeks. It will be a substantive motion. Judge, I'd ask to exceed the page limit on that. I can file something in writing if you're not comfortable with that. But
no, that's fine. You can exceed this page limit in this case.
Okay, and Judge, I'd just like to make an objection for this particular hearing being broadcast by any media outlets. The last one, where not a whole lot exciting happened, was broadcast in multiple places. This one, I would say, we could characterize the same way. I'm not making a big substantive argument here. It's simply, I don't believe, under the Arizona Supreme Court Rule 122, the media has complied with the process they're supposed to, which is to file a request, then we get a chance to object, and then we have a hearing or discussion about it. So simply procedurally, I would just ask that it be ordered they not broadcast this hearing on any of their channels or websites.
All right. Well, I'm going to deny that motion. This is an open criminal proceeding. I haven't had any motions to the contrary to seal these proceedings. So that's the ruling for today.
Thank you.
All right. Thank you.